Mehler, thank you very much for sitting down with me. So this morning in court, we saw James Cotter appear for the first time before Judge Bettis. He was asking that the judge remove his GPS monitoring and also allow him to travel more than 75 miles outside of Bexar County. Are these conditions of release standard for the nature of these charges, which include possession of a prohibited weapon and tampering with evidence?
They're not common. We would usually see GPS monitoring pursuant to bond violations, actually. They're not typically imposed immediately at magistration. The travel restriction that he was under is standard in Bexar County with felony GPS monitoring.
Today, his attorney argued to the court that his client hasn't violated conditions of release. He has business interests in California and family in Oklahoma, and the judge granted, in part, those requests by removing the travel restriction, but leaving the GPS monitoring. The state had argued to the judge that because Suzanne Simpson's body hasn't been found, that they would like to keep the GPS tracker on Mr. Cotter. Is that something that, was foreseeable?
Yes, the judge's job at this juncture with this hearing is to weigh the rights of the accused with the public interest, that is the safety of the community as well as securing the appearance of the accused in court. So in this case, it appears the judge has done that because he's allowed Mr. Cotter to travel. So he's conceded in a very real way that there's a necessity here because Mr. Cotter has not been convicted, he's only been accused. But at the same time, the state has articulated to the judge a concern related to an ongoing murder investigation and the potential for flight, as would be somewhat connected to the idea of hiding a firearm, prohibited weapon, that there may be an interest in fleeing. And so the judge has left the GPS in place and, for lack of a better way to put it, has split the baby and tried to make everybody happy.
So for the people that don't see these kinds of cases, that aren't really, involved in the criminal justice system like a defense attorney would be, was this a reasonable request of Mr. Cotter?
Yes, because the defense, their job as defense lawyers is to advocate for everything they can get, the best they can get for their client. Reduction of bond, reduction of the restrictions, removal of the GPS. Their job is to go ask for everything. That is their job in defending their client. Do they expect to win on every point? Most defense lawyers would tell you no, but you have to go ask for it all.
And something that came out in court today was that there's already terabytes of information in this case. Suzanne disappeared in October. We're now in February. As somebody who has handled a murder case before and handled, felony cases before, what do you think, this copious amounts of data means and what's in there?
When you see numbers like that, terabytes, generally it's digital data. Things like extractions of cell phone data, which could be literally hundreds of thousands of text messages, GPS locations for every place that cell phone has been carried the entire time it was active, thousands of emails, all of the data that's contained in a cell phone, each individual piece, when it's extracted, it ultimately forms massive data files that then must be combed over and gone through for whatever significance they may hold.
So when we hear terabytes of information, the public shouldn't assume, okay, the state has a slam dunk case with a bunch of evidence.
No, those numbers don't indicate a massive stack of evidence against the accused. They just indicate a massive stack of evidence, and a lot of it may be completely irrelevant to the facts of the case. Without actually seeing it, we can't know. But yeah, the presence of massive amounts of digital data doesn't indicate the quality of the evidence or what it might indicate at all.
Do you think that that number will only get bigger, or the trove of data will only get bigger as the case progresses?
Yes. Generally speaking, there will be more evidence that'll be uncovered. There'll be more evidence that'll be tendered to the defense. Until the investigators reach that point that they think they have everything, we could fully expect that they'll continue searching and potentially uncovering new data, new information, new evidence.
In a case like this where there is no body, switching to Mr. Simpson's cases, in a case like this where there is no body, talk to me about that burden that the state's going to have to overcome as the case moves forward.
Without a body, they're going to have to prove some way, somehow, that Miss Simpson is in fact dead. Without actual concrete proof that she is in fact dead, it would appear just on its face it's going to be exceedingly difficult to prove that Mr. Simpson killed her. Despite whatever evidence may be there, beyond a reasonable doubt is such a high burden that if it's possible that she's, run off, there's a whole slew of other explanations for her absence besides her death if they can't prove she's actually dead.
I saw in court records, I believe that Mr. Cotter is going to be back in court and has been set for trial on sometime in May, I believe it was. Do you think that this case stands to go to trial this year or May even?
It could, but I would expect it not to, simply because the amount of data at issue, the amount of time it takes to review it, everybody involved has to go over it all. And to get ready for that trial, to engage the proper experts for digital forensics, for instance, to allow them time to work, to arrange everybody's availability to testify, all of the witnesses' needs, to get it all together with just the volume of evidence that's being discussed seems highly unlikely on such a short time frame.
Balancing speedy trial and this, growing body of evidence, do you think that either defendant would push for a trial sooner rather than later because it would potentially mean that the state wouldn't be able to prove their case?
That would be a valid strategy potentially for either defense team to choose. Whether or not they will would surely be between them and the accused. Does it create problems? Yes, it would. If the state is having problems marshaling the evidence or marshaling the witnesses, a compressed timeline forces them to work faster. It does force them to work harder to try to make it happen. It's just additional pressure. So whether or not that happens, as I said, remains up to the defendants and their counsel, but at times it could end up being a very valid strategy.
And something that you and I have talked about in the past is this rolling production of discovery, sometimes even a few weeks before trial. The state is finding evidence that, hey, we need to give you this cell phone number. With a case like this, do you anticipate there being any sort of discovery hurdles like this or discovery issues that might come up in what the state has turned over?
Well, as defense lawyers, we're always very skeptical of late disclosures on the eve of trial, as we're leading up to trial, when things have been open for months, if not years, and all of a sudden there's new evidence that seemingly has been laying there for a period of time. As defense lawyers, we're always skeptical of that. That is also when you run into cases where lawyers are asking for more time due to late disclosures of evidence because they don't want to go to trial without knowing what's in that black box they just got handed. So do I expect those problems? You always anticipate them as a defense lawyer. And it's not just to say that the state of Texas is at fault, right? You have your police agencies, you have the district attorney's office, you have a lot of moving parts that frankly do poor jobs of communicating at times. And as a result, you do end up with these disclosures where oftentimes defense counsel has no choice but to ask for more time.
Simpson is due in court next week. What do you think we can expect from this appearance? It's my understanding that there aren't any real outstanding motions at present, but I mean, if you're coming to court or if you're scheduled to appear in court, what do you think we can expect next week?
As outsiders looking in, not very much. We can expect Mr. Simpson will be maybe not even brought into the courtroom, depending on what's actually happening. His counsel will confer with the state, but it's almost assured that they are extensively conferring outside of court as well. So there shouldn't actually be a lot going on. It's a routine docket appearance. The court may inquire as to progress towards a trial, an eventual resolution, whatever that looks like. But generally speaking, as an outsider looking in, not a lot's going to happen.
Okay. And just in terms of strategy, if you can speculate, you had mentioned earlier that, defense attorneys are going to ask for everything that they can get. We haven't really seen these asks from Mr. Simpson's counsel in terms of bond reductions and things like this. Why do you think that might be?
That's a tough question as far as what defense counsel is aware of, what defense counsel knows, what evidence has been turned over. Without knowing anything about it, it's very tough to second guess or Monday morning quarterback any decisions that are being made. We have seen, I believe, a bond reduction request. We've seen Mr. Simpson's counsel have a hearing over the ability to communicate with his children. So we have seen some of that, but as far as what to expect or what they might try to do, without knowing more, I'm very hesitant to speculate on that.
Any final thoughts on this case or anything that you'd like to drive home to the public as this case unfolds?
Patience. And that goes regardless of where you stand on the issues here. The wheels of justice do grind slowly, and that goes for everybody involved. So I know that it's highly publicized, it's getting a lot of coverage and a lot of attention, and people do want resolution. That's just human nature, but unfortunately the system, it takes its time. So that's what I would just tell everyone: be patient. It will ultimately be resolved.